period. And I appreciate you, Ora, for being here today. I want to thank everyone who is going to participate, especially Ora, who is the best person in the world. I'm going to read your beautiful bio, and I am going to allow you, or please enlighten us with your beautiful wisdom. Ora is the Director of Litigation and Policy at the Eviction Defense Collaborative. It's the lead agency for the Tenant Right to Counsel program in San Francisco. Ora has over 35 years of experience in tenant advocacy, and prior to coming to EDC, she was the Director of Clinical and Public Interest Law Programs and Professor of Law at John F. Kennedy University. She has a distinguished history of community service and pro bono activities and has received many awards from the state bar and local bar associations in recognition of her expertise and legal assistance, particularly in low-income communities. Ora has been a frequent presenter at workshops and seminars, especially for us, and for both legal professionals and the general public. So I'm going to close my mouth because Ora has so much knowledge and wisdom to share with us. So thank you very much, Ora, for being here today.
So I'm happy to be here, and I really want to thank the center for inviting me. I know that a lot of folks are under a lot of stress and worry about what it means to try to navigate keeping your home in this period of time after all the moratoriums have lifted. So I'm going to go into some detail about that, but I just want to start with the general statement that people should just take a deep breath and hang in there, because there are still a lot of protections in place for folks. And let me see if I can get this to work. That's not the screen you want to see. Let me. There we go. Are you able to see that? Can you see my slides?
Yes, we can see your slide
Great.
presentation as well as the slides on the left side.
Okay, so let me go ahead and. This is. This is not. All right. So I'm going to be talking with you about how to navigate tenant COVID protections in this period of time after the moratorium. And to talk about this, I'm going to be referring to a body of law that, as a shorthand, we refer to as AB 832. The California legislature passed a series of protections during COVID to address the difficulties for tenants in trying to keep their homes and stay current in their rent. And the shorthand for that combination of laws that are now in place, we're referring to by its statutory name, which is AB 832. And this statute creates three key time periods for the different protections. And although we've passed through the first time periods and we're now in the third one, they're still very relevant. So I'm going to talk about the meaning of each of those three time periods. The first one is referred to as the protected period. It began back in March of 2020, when all this fun with COVID first began, and it went through the end of August of 2020. During that protected time period, tenants could never be evicted for failing to pay their rent. So to this day, anybody who did not pay rent from March through August of 2020 can never be evicted for failing to pay rent from that time period. It's not true that that money is not still owed. So we're going to be talking a little bit later in this training about what landlords can do about that rent that's still owed from that time period, but it will never be evictable money. The second period of time began on September 1st of 2020, and it ended at the end of September of 2021. And that second window of time is referred to as the transitional period. Rent for that second time period cannot ever be the basis of eviction as long as the tenant paid at least 25% of the rent, and they had until September 30th to pay that 25%. So they could pay 0 rent from March till August, and they had to pay 25% from September through September. September 1 of 2020 through September 30th of 2021 is a total of 13 months. So basically 25% comes out to 3¼ months rent. So we all had until September 30th to pay 3¼ months rent to avoid eviction. We have now moved into the 3rd period. So beginning on October 1st, we began what's called the recovery period. And this period of time is going to continue till the end of March of 2022. Beginning on October 1st, we had to start paying 100% of the rent. And if we failed to do that, we could be subject to eviction proceedings. But all the way until the end of March, there's some extra procedural protections that are going to be in place. So even though we have to start to pay our full rent, we're not back to the old world of how landlords could evict us. There's still a lot of protections that are in place. Those protections will also apply to tenants who didn't manage to pay their 25% by September 30th. During the time that the COVID moratoriums were in place, there was a rule that landlords had to give a lot of informational notices to tenants. The time periods for those informational notices have all expired, but the reason I'm still highlighting them and mentioning them is if somebody never got those notices and the landlord later tries to evict them, that's going to be a defense to the eviction. So if you did not pay your rent from March through September of 2020, by the end of September of 2020, you were supposed to get a written notice telling you about your rights from the landlord. Same thing for the next period of time, all the way up to February 1st of 2021. If you owed some rent, you were supposed to get a notice on February 28th that told you about your rights. And for the last period, if you owed rent up until July 1st of 2021, then by July 31st, you were supposed to get an informational notice telling you about your rights and protections. If on September 30th, February 28th, or July 31st, you were supposed to get one of these informational notices and did not, you'll be able to raise that as a defense if the landlord later tries to evict you. Now, I've mentioned that there is a significant amount of rent that can never be the basis for an eviction. That is 100% of the rent from March through August of 2020, and 75% of the rent from September of 2020 through September of 2021 can never cause an eviction of a tenant who didn't pay it. That money is still collectible. So I'm going to talk about the difference between evictable money and collectible money. By collectible, I mean it's going to be treated the same as any debt that a person might have. So if you have a credit card bill and you don't pay it, you owe that money, but it's not going to cause you to lose your house. So the failure to pay some of this collectible money can cause efforts to try to collect the money in court, but it can never cause a tenant to lose their home. Those COVID rent debt collection proceedings can begin in small claims court starting on November 1st. So that's today. Happy Collections Day. Starting today, the deferment on collecting rent has ended and landlords begin to sue their tenants in small claims court to try to collect this money. Normally there's some limits on what can be sued for in the small claims court, and all of those limits are waived. So the limit of only being able to sue for $10,000 has been taken away. No matter how much money a tenant owes, the landlord could go to small claims court to try to collect that money. That's not such a bad thing because the tenants will have an easier experience in small claims court than they will in sort of full-blown superior court. In small claims court, people are on an equal footing. There's no lawyers involved in the process. There won't be a lawyer for the landlord, and the tenant speaks for themselves as well. Tenants are allowed to file what's called a counterclaim. That means if there's things that you want to sue the landlord for, you could cross-claim when the landlord comes after you for the rent. So maybe you didn't pay your rent, but the landlord wasn't doing repairs. And when it rains outside, it rains in your living room. Well, you could cross-complain for that. The tenant also has a right to appeal if they lose in small claims court. The landlord is what's called the plaintiff, the person who brings the lawsuit. And in small claims court, the plaintiff, if they lose, They get one bite at the apple, it's done, they cannot appeal. The tenant is the defendant. If they lose, they could do an appeal, and at that next stage, they could have a lawyer help them. There are also rules related to the COVID pandemic that prohibit the landlord from charging any late fees. Even if normally your rental agreement says that if you don't pay the rent in time, you owe a late fee, the COVID rental debt can never cause you to owe a late fee. And the landlords cannot maintain what we call a rolling rent ledger. That means if you pay your rent this month for October, your landlord has to apply it to the month of October of 2021. Actually, we're in November now, so the landlord has to apply it for November of 2021. They can't apply it to last month or the month before that. So that will help with making the difference between that collectible debt and the evictable debt. As long as the tenant remains in their unit, the landlord also cannot apply your security deposit to the unpaid COVID debt, unless you agree to let them do that. You're not compelled to agree to that. Now, if the tenant moves out, the landlord can deduct from the security deposit for this unpaid debt, but they can't do it the whole time that the tenant lives there. And there is some protections in place to help tenants with their credit reports. So if there is an eviction case because of COVID debt, or if there's a small claims court collection case, those are masked, which means they're hidden from the public, and they won't create an adverse credit report. And reports of credit problems because of COVID rental debt can never be used to deny a tenant future housing, either by a landlord who screens because of bad credit or because of one of these credit agencies or screening services. So even if you're sued in small claims court, that will never be able to be used to prevent a future landlord from renting to you. Most importantly, I'm going to be talking about rental assistance programs that are available to help tenants with this debt that they may owe. If the landlord tries to take a tenant to small claims court because of COVID non-payment of rent, the landlord is supposed to first try to get that debt paid through these rental assistance programs. And the court can reduce the amount that the landlord can recover from court by the amount they should have received had they gone through the rental assistance programs. Similar protections apply to eviction proceedings. So let me begin by talking about how evictions work in California, regardless of COVID. If you as a tenant don't pay your rent and the landlord wants to evict you, they begin that process by giving you a written notice explaining how much you owe and demanding that you pay that rent or be subject to eviction. During the COVID moratorium, that eviction notice was extended to 15 days. We're back to the regular world of 3-day notices. But if the landlord tries to evict you now for that rent that was due prior to October 1st, maybe you didn't pay the 25%, you're still required to get a 15-day notice for that older rent. But if you're having trouble paying the post-October rent, that's a 3-day notice. If you get a 3-day notice and you pay the rent within the 3 days, the whole problem goes away. There's no eviction. If you're not able to pay it within 3 days, the landlord's recourse is to begin a court proceeding to evict. They have no other tool available to get you out of the house. So they're not allowed to change the locks. They can't cut off your utilities. They cannot throw your stuff out of the house or threaten you. None of those processes are allowed. And if the landlord tries to do any of those things, it's illegal. And there's criminal penalties and very serious civil penalties, and you could keep your home. What the landlord could do, and all that the landlord could do, is to begin a court eviction process. And that eviction process is called an unlawful detainment procedure. What's new and different during this recovery period from COVID is that there's added protections in that unlawful detainment procedures. The unlawful detainer, like any lawsuit, begins with the plaintiff, here the landlord, filing what's called a complaint. That's where the landlord tells their story about the eviction. And normally after the complaint is filed, the court issues what's called a summons. The summons is the paper that requires the tenant to come to court and defend themselves. During this COVID recovery period, there's a special rule that says that no summons can issue in these eviction lawsuits unless the landlord shows to the court that the landlord applied for rental assistance and was denied. So your landlord cannot get a summons to evict you, and you'll never have to appear in court unless the landlord goes through the rental assistance process and gets a denial. A denial means one of three things. There might be a denial because the tenant was ineligible. To be eligible for rental assistance, the tenant has to be at or below 80% of what's called AMI, area median income. Well, median income in the Bay Area is quite high, so any of us who make it as a single person, $100,000 or less, we're eligible. So most of us who are struggling with non-payment of rent are completely eligible for this program, and that will not be the basis for denial. The second basis for denial is because the tenant does not cooperate with the process. So it's up to all of us to make sure that the landlord does not get denied for that reason. If the landlord applies to the rental assistance program, and I'm going to provide a little bit more information about that in a few minutes, the tenant will get notified of that application, and the tenant themselves will then have to participate as well by sharing their income information, their payment of rent history, copies of their rental agreement, that type of paperwork. You have 20 days to respond from being notified that the landlord made their own application or from getting your 3-day notice to pay. If you ignore that 20-day time period, then the landlord could tell the court that you weren't cooperating and they could go forward and get a summons. So if you hear nothing else from what I'm telling you in this workshop, the most urgent thing that I can say to you is please don't ignore your landlord's application for rental assistance. Instead, you should cooperate and participate in that program as well. It will help you tremendously. The final basis for a denial can be because the program runs out of money. There's a great deal of money that's been given to the state from US Treasury funds to provide this rental assistance. So right now, everybody who's applying is able to get that assistance, but eventually the programs will run out. So it's really incumbent on all of us to apply as soon as possible and participate now so that we could avoid evictions later after the programs run out of money. I've just talked about one of the most significant protections in the eviction process, and that is the landlord cannot even get their summons if the rental assistance program is being used properly. But there's a second protection if the landlord gets over that first hurdle. So let's say the landlord somehow manages to get the summons issued, serves papers to the tenant, and the tenant is now involved in fighting the eviction. There's several important things I should say to you about this process. The first is that anybody who lives in San Francisco has access to a voter-approved tenant right to counsel program. So back in 2018, the voters of San Francisco passed Proposition F, which says that all tenants who are being evicted have a right to a free attorney. So anybody who finds themselves with a summons for unlawful detainer should immediately be contacting the Eviction Defense Collaborative, and I'll be giving you that contact information, so that you could get your free attorney to get help and keep your home. Whether you're in San Francisco with the right to counsel or in other parts of the state, you also have access to a protection that comes from AB 832. It's now enshrined in our Code of Civil Procedure, which allows the tenant to be protected from a forfeiture of their home if they could show to the court that they, as a tenant, have been approved for rental assistance. So once again, this causes me to really stress the urgency of all of us applying as early as possible for rental assistance to make sure that we're not evicted from our homes. Once a tenant receives an approval of their application, even if they don't yet have the money, so maybe the actual payment of the cash is still pending, but the request has been approved, the tenant can get what's called a stay in the eviction action. A stay is a legal word that basically means it's paused or delayed. So anywhere in the eviction process, the tenant can go to the court and submit papers that show that they've been approved for an application for rent that's going to cover all of the debt that the landlord is seeking to recover. They can make that application for a stay anytime up until the moment that the sheriff's eviction happens. So at the very end of a court lawsuit, after it goes to judgment, it's not too late to ask for a stay. Even if the sheriff has already posted the property with an eviction notice, it's not too late to ask for a stay. So anytime in the process, where the tenant can show to the court that they've been approved for rental assistance, they could do this request for a stay. At the moment the request was filed, it freezes the whole process wherever it is. Even if the sheriff is about to come and knock on your door, it freezes them in place and that eviction cannot happen. Instead, it requires the court to set a hearing, and that hearing will be 5 to 10 days later. And at the hearing, all that the tenant has to do is produce evidence that they've been approved for rent assistance in an amount that will fully cover the amount that's being demanded in the complaint. If by the time the hearing happens, the payment has already come through, the court's going to dismiss the whole lawsuit and the tenant is safe. If the payment has not yet come through, the court will continue the matter for another 15 days to keep on checking in on the status. So I'm going to just do a quick summary of the things that I've talked about, just to reiterate. I want to remind everybody that they cannot be evicted at this time for any non-payment of rent that occurred before August of 2020. And they can't be evicted for any money that became due between September of 2020 and September of 2021, as long as they paid at least 25% of the rent for that time period. Beginning in October, they can be evicted either because they failed to pay the 25% that was due for the prior 13 months, or beginning October 1, we have to start paying 100% of the rent. But even during this time period where evictions are going forward, they will not proceed if everybody's participating in the statewide rental assistance programs. The landlord cannot even get their summons, and the lawsuit won't be served on the tenant if everybody's participating in the rental assistance program. And if you get through that first hurdle, the tenant can freeze the process and make it go away if they could show they have an approved application. But let me now refer you to some resources that will be able to help you with these protections that I've been describing. In terms of what to do if you're served with a summons and complaint, which is the paperwork that shows that there is a court-based eviction lawsuit, you should reach out immediately to the Eviction Defense Collaborative. As I have already stated, if you're in San Francisco, you have access to a free attorney through the Right to Counsel program. Our email is legal@evictiondefense.org, or you could call us on our phone. Either somebody will answer or you'll leave a message and we'll get back to you. And our phone number is here on this slide, 415-659-9184. We're also open for limited in-office hours on Monday, Wednesday, and Friday, in the morning from 10 to 11:30, and in the afternoon from 1 to 2:30. If you have good phone service or email, you should probably communicate with us that way. We're trying to limit our in-person contact because of COVID protections and social distancing precautions. But if you don't have good phone service or internet, or if you're pushing the 5th day to respond to your papers, you should come into our office right away. When you get served with a summons and complaint, you only have 5 days to respond. And if you don't respond within that time frame, you get what's called a default judgment. Basically, you lose without being able to defend and tell your side of the story, and you don't want to have that ever happen. If you're outside of San Francisco, there are other agencies within your area that can help you. You should be contacting your local Bay Area Legal Aid office if you're low income, or your local bar association for lawyer referrals. If you are looking for rental assistance, if you owe any back rent, whether it's evictable or not, you can avail yourself of the rental assistance program. You absolutely want to do that if you have concerns about rent that might cause eviction. That is rent that's post October 1st or pre-October 1st if you didn't pay the 25%. But you could also obtain rental assistance to protect yourself from those collection proceedings in small claims court, which I mentioned. The easiest way to get that assistance is go to the statewide website. The website is found at housingiskey.com. Very easy to remember, housingiskey.com. And at that website, you'll be directed to the right location for the county where you live. And you can immediately start to fill out an application as a tenant seeking the rental assistance. If your landlord has also applied, your tenant application will be matched up with your landlord application and submitted together. But even if your landlord's not participating in the program, you yourself can participate fully and get all of the protections that I've described. Here at the EDC, we also have a program that helps with rental assistance. So if you're struggling with the Housing is Key website and want somebody to help you do it, or if you're for some reason denied or not eligible and want to see if there's other funding that could help you with your rent, you could avail yourself of our rental assistance program at EDC, EDC Radco. Reach out to us by email at edcradco@evictiondefense.org, or you could call us at 415-470-5211. Or we have the same limited in-person hours at our office at 1338 Mission Street. And again, those hours are Monday, Wednesday, and Friday, 10 to 11:30 in the morning, or 1 to 2:30 in the afternoon for rental assistance as well as for legal assistance. So I hope that that answers the questions that folks had about this. I don't think that we have people in the audience right now. I'm happy to answer questions or not.
Right. I appreciate you, Ora. I just want to say Timothy Hampton, the Community Programs Manager, as well as we at the SF LGBT Center, really appreciate your valuable knowledge as well as your wisdom. And we want to encourage anyone who is facing eviction to definitely reach out to you all. And we want to continue to spread the message about the valuable information that you have in people during their experience of eviction. So thank you very much on this end.
You're so welcome. And again, thank you for giving me this opportunity to share this information and try to help keep people in their homes.
Thank you. Have a good one, and you stay safe out there, okay?
Thank you. You too.
Bye-bye.